The constitution of any state is the statutes with which the people have agreed to be abiding. Now, for effective running of governance and also its institutions. However, as society evolved, the need for a constant review of the constitution to reflect new realities is one that never ends. The Nigerian constitution has undergone several amendments pre- and post-independence, from the days of colonialism to military regimes and now the Fourth Republic. While Nigeria has departed from the era of making laws by decrees, the legislative process of amending the constitution under the democratic dispensation is not without its own challenges. In legislating laws, the conflict of interest versus the obligation of lawmakers as representatives of the people has been a constant feature in lawmaking. Amending the constitution in Nigeria is further complicated by the requirements of a two-thirds majority of at least 24 state assemblies before final adoption by the National Assembly and then subsequent transmission to the President for assent. This is considered by some analysts as one of the reasons why important amendments to the constitution does not see the light of day due to political manipulations. For instance, in the last constitutional review, it was to the dismay of many Nigerians that the state assemblies rejected a bill proposing financial autonomy for local councils and state legislature. How important is the role of lawmakers at the subnational level? And will some of the important changes sought by Nigerians pull through, or will it be another exercise in futility? This is the issue in focus today. I am Ayuba. Thank you for joining. Before we begin the discussion, let's take a look at some of the bills contained in the constitutional amendment before the lawmakers. All right, thank you for staying. And there you have it, some of the bills that are being proposed by lawmakers from the National Assembly and now being transmitted to the state assemblies for their own considerations as required by the law. Now, to give us perspectives on this, we have in the studio Jide Ojo, public affairs analyst, and he'll be talking to us about some of the reactions that have trailed the constitutional amendment. Thank you for joining us.
Thank you for having me, Ayuba. Happy Sunday.
Thank you. Thank you.
It's a pleasure.
Yeah. All right. Now, I mean, constitutional amendments, this is more like a routine, for us. We've always seen this happen in the life of virtually every assembly. I mean, from 1999 till date, we've had several amendments. But how much has changed, really, in the way governance is being done in Nigeria? Especially if you look at conversations, age-long conversations, such as the issues of restructuring and the likes.
Let's put things in perspective. Like you rightly said in your background, this has been a routine exercise. Some has failed, some have succeeded. Up until 2010, all previous attempts before then to amend the 1999 Constitution of the Federal Republic of Nigeria were futile. In 2005, we have the National Political Reform Conference. Then we had several attempts to amend the Constitution. Not until 2010 did we succeed, where we have very comprehensive amendment. After the 2008, what was known as Electoral Reform, the one headed by Justice, former Chief Justice of Nigeria, Justice Muhammad Lawal Ways Committee, when it submitted its report in December 2008, after it was inaugurated in August 2007, shortly after the inauguration of President Umaru Musa Yar'Adua. From that time through to when the Ways Committee was inaugurated, when it submitted its report in 2008, by 2009, President late Umaru Musa Yar'Adua initiated a wide range of constitutional amendments, which culminated in the 2010 amendment of the Constitution, most of which has to do with electoral reform. I recall that it was in 2010 we had INEC being put on first-line charge on Consolidated Revenue Fund. The number of judges at the Election Petition Tribunal was reduced from 5 to 3. Then we had the separate Election Petition Tribunal for governorship and then for presidential. Then we have one for legislative and to take legislative. Then there was age reduction for commissioners in INEC. It used to be that if you are not 50 years and above, you could not be chairman of INEC. That was reduced to 40. Then the one for the national commissioners, I think, was reduced from 40 to 35. And then resident electoral commissioners were reduced to, I think, 30 or 35. So, those are the kind of... Then in that 2010, the Constitution was altered 3 times. In fact, the third one was the one that gave legal backing to National Industrial Court as a court of record. Mm-hmm. Up until that time, National Industrial Court was not a court of record. So now the National Industrial Court was strengthened. That was the third alteration. They call it alteration because that's the language of the Constitution. It's not amendment, it's alteration. Now, the last one before this current one was done in 2018, when out of the 12 that made the court at the State Assembly, the president only assented to 5. And the most prominent one among them being the Not Too Young to Run bill, which was signed on May 31st, 2018. Then we had the one that gave INEC more days to conduct runoff from initial 7 days in the Constitution to 21 days. The one that talks about if you serve out the tenure of your principal, you can only do one more time, and you cannot. So, for instance, that is being dusted that Goodluck Jonathan cannot come back as president because he served out the tenure of Umaru Musa Yar'Adua and then did a substantive one term. And now, if he wants to go for another term, the Constitution has forbidden anyone with that kind of record to both for president and for governor. Now, this I need to let our viewers know all of this because although from the civil society point of view, we actually want a new constitution altogether. So that it's process, because the argument is that this 1999 constitution is a decree. It was a decree, Decree 34 of 1999, before it was now worked on by the National Assembly and it became 1999 Constitution. And people felt only 50 people, in fact 49, because one of the 50 declined to be part of the committee, gave us that constitution, and that it was not process-led, it was not autonomous, it was not pro-people. So the argument from the civil society point of view is that we should have a new constitution, just like the Kenyans had in 2007. But the National Assembly has been against that because it felt it's representative enough. 469 people, 360 at the House of Reps, and 109 senators are representative enough, and whatever needs to be done in altering the constitution, they are up to it. But what we have seen is that it has largely been incremental.
Okay, now the thing is that, yes, we have a constitutional authority in the National Assembly to be the ones to, amend whatever needs to be amended. And even if there's a need for a new constitution, they have that responsibility. But there seem to be some issues with, dealing with the issues of substance in the constitution that, touches the heart of some of the, I would say, conflicts that we've had, or the kind of disagreements that we've had in several quarters. For instance, this long debate about restructuring the country, for almost every attempt that has been made, it always hits the brick wall, and there's a resistance, sometimes not even from the national level, but even at the sub-national level, who are supposedly the beneficiaries of some of these legislations. For instance, if you take a look at issues of taking some items off the exclusive list to the concurrent list, which the National Assembly has proposed. If you take a look at certain issues that has to do with devolution of power, that's about the exclusive legislative list. Other issues, that has to do with also the state assemblies and financial autonomy as well for local councils and the rest of them. It's shocking, really, to find that subnationals, do not endorse provisions like that.
Well, more pointedly, I think you are referring to, first I must say that we are not unanimous on what should constitute restructuring. There is no unanimity of views. There are disparate views from the north and from the south, because the kind of restructuring that is being conceptualized in the southern Nigeria will put the north at a disadvantage. And so the northern elites are always resisting. And that's why you see even the president is not sold on the issue of restructuring. However, consciously or unconsciously, there are restructuring ongoing. For instance, the issue of VAT, value-added tax, that Governor Nyesom Wike went to court for. And the Federal High Court in Port Harcourt said, yes, VAT is not on the exclusive list, and that the states should be allowed to collect VAT. That is on appeal now, and some states have joined. I think Lagos State government has joined, and others. Now, that if eventually this gets to the Supreme Court and there is a pronouncement that value-added tax should be collected by the states, that is a restructuring, a fiscal restructuring.
Yes.
Because we are talking of a sizable, significant income into the federation account. I don't know if you get me.
Yes.
Now, routing it through the law, you raise a very valid point that why are the subnationals even kicking against what will liberate them, what will give them freedom? The issue of local government autonomy, the issue of financial autonomy for state judiciary and state legislature. Again, it points to the whole issue of who are the governors? And are the governors allowing independent actions of their state houses of assembly? The answer is no. The governors in many states funded the election of their members of state house of assembly. It's like a bandwagon. So when you see a prominent person running as a governor, if you go this election season, you will see it. About 5-7 people will join that governorship candidate in sharing a billboard, which invariably may translate to the fact that he's actually co-sponsoring their emergence. And once this happens, you don't expect people whose elections were funded by the governor to be against the same governor. And that's why you see the governor dictating to the State House of Assembly on how they should vote on issue of constitutional amendment. That is what has been robbing us of vibrancy and much pace in constitutional amendment. Now, when you did that backgrounder, you said out of 68 items that were tabled, 46 made the court. That means the National Assembly voted in favor or passed the 46 bills and rejected 22.
Yes.
Out of these 46, you will be shocked that by the time it gets to the State House of Assembly, many of those noble provisions that we are excited about, if the governors don't want it, they won't make it. The issue of independent candidacy, for instance, it's not today that it has been making the court at the national level. But if the governors don't want it to happen, it will not happen. You won't get the 2/3 of them to support independent candidacy. The issue of local government autonomy, I recall in the 2018 effort, it got passed at the national level, but got rejected at the State House of Assembly level because there were not enough states supporting that local government autonomy. There's one that confused me, the issue of financial autonomy to state judiciary and legislature. I thought that has been done and dusted with 2018, and that's the whole essence of why the president wanted to give effect to that constitutional amendment or alteration. That was why he made executive order 10, which, of course, the Supreme Court has said was ultra-vires, that should not have been done. And I don't think the Supreme Court decision has negated the provision of the Constitution, which has already been signed into law in terms of financial autonomy to state judiciary and state legislature. But I saw that those two were still one of the issues that were debated upon. I need to be educated on that. But by and large, coming back to the question about restructuring, like I said, we are not very clear about the kind of restructuring we want. For instance, APC believes they avoided the use of restructuring. They used devolution of power.
Okay, great. So let's leave the word restructuring. Maybe it's now a buzzword in our political atmosphere, and a lot of people have their own understanding of what the restructuring means, political, economic, and structurally. But critically, there are issues that affects our subnationals greatly. Like taking off certain items from the exclusive list that will strengthen these subnationals. How important is the role of state legislators and governors in this sense? Because clearly there's an obligation here, for the people. Today we talk about insecurity in the country and how that some of our states are largely redundant and depending mainly on the on the central government, that's the federal government, for revenue and the likes and the rest of them. There are clear ways that we can make these states more vibrant, and by the time we make some of these changes in our constitution, that would have done the job to a large extent. So where do we need to put aside, our own personal interests and also the obligation of the state?
Well, again, going back to my earlier comment about the state houses of assembly being appendages of the governors or government house, it is what is robbing off of that desirability to have fast-tracked amendments of the fast-tracked alteration of the Constitution. And I see what took place last Tuesday, which is 1st of March, as a laudable thing, if it was scaled through. Laudable in the sense that about 5 or 7 items were devolved from the exclusive legislative list to the concurrent legislative list.
Yes.
Issue of electricity, prisons, issue of
airports.
Airports, yeah, that's airports, and there is also one other one popular. So if you look
Even
at
the railway.
the railway, airport, electricity, and prisons,
yes,
and one or two others. I think
criminal
some newspapers reported about 7 issues that were removed from the school. The point is, it gladdens my heart that this is happening, and I do hope that we'll get sufficient number of state assembly backing this up, because this is part of the restructuring we are talking about, or what APC calls the evolution of power. APC, when he set up the Malam Nasser El-Rufai committee way back in 2016, 2017, they sat for 6 months and came up with a beautiful report. I was there when the public presentation was made at Sheraton Hotel and Towers here in Abuja. I was there and I have copies. I also have had copies of this Evolution of Power committee report. But it's been gathering dust, so not much effort has been made. But you see, for us to celebrate this, ultimately, the governors may have had their way, in a sense, to have this removed, but there's also another hurdle. Even if we have 24 state houses of assembly passing this legislation, the president will withhold the powers to assent to it. Let me give you an illustration. In the one that accumulated in the last alteration exercise, about 60 items was, the National Assembly started with about 60 items. By the time they voted, it came to about 32, 33. By the time they sent this 33 to the states, only 12 made the cut. You can see the pruning. From 60 items, just like this one, 68, from 60 items, 33 made the cut. Then they sent the 33 to the states. Only 12 got 24 state endorsement. But did you know how many was signed by the president? 5. Only 5 out of the 12.
Again, that's another issue. So,
which is another issue that we have to contemplate.
I mean, after all the processes, presidential assent alone can determine, whether
the success or the failure of all of this. So we cannot be too excited, but we laud the National Assembly.
But the National Assembly has the veto power. We
which
haven't seen that being exercised.
Which is really used.
I mean, it's
and you see, my brother, the National Assembly has veto power. But if you look at the way our federalism is structured, it is a subservient system of government. We have an aged president whom everybody sees as Baba. In fact, that's the way he's called. They call him Baba, say Baba. So whatever Baba says is what stands. You could see the grandstanding, even with Electoral Act amendment. In December, the National Assembly said, we are going to override the president's veto. But did they do it? Eventually, they came back and reworked the bill. But in doing this, we should not lose sight of something. Because the National Assembly has left this constitutional amendment till this political season. Exactly. It will be difficult to even get 2/3 to override the president's veto in the event of him withholding assent. Because from next month, Ayuba, party primaries will start.
And I'm wondering why, we are having this constitutional amendment, in this year, 2022. This is eve of elections. I'm wondering, we've had 4 years, of this tenure. Yeah. So why now, really?
Why now is because of cash. Every year, each of the chambers of National Assembly votes 1 billion naira for constitutional amendment. 1 billion. So 2 billion every year. They don't want, it's a honeypot. Because if not, look, when they wanted to do Electoral Act amendment, they set up joint committee of Senate and House of Reps. The Senate Committee on Electoral Matters and the Senate Committee on INEC and House of Reps Committee on Electoral Matters, headed by Aisha Duku, Honorable Aisha Duku from Gombe. was the one that heads the electoral House of Reps Committee on Electoral Matters, while Senator Kabir Gaya of Kano State, former governor of Kano State, heads the Senate Committee on INEC. But you know, because there isn't much funds, so they went into joint committee. But on constitutional review, they didn't do joint. The deputy speaker is heading the one for House of Reps. The the deputy president of the Senate, is heading another. I recall that when they wanted to do public hearing, Senate did its own public hearing different from that of us. Why should that happen? In a serious climb, you integrate, you manage resources. But because of this 1 billion, they have to be politically correct, delay unnecessarily. Because this, did you know that the public hearing was done way back in June last year? Because I recall I was in Jos when the House of Reps public hearing was holding. That was last June. So they could have fast-tracked. Within 3 months, the report of the public hearing could have been ready. Before the end of last year, we could have been done and dusted, at least. Because right now, but this is the first layer of effort. The National Assembly has voted. Now they will compile the vote, send it to the State House of Assembly. There is no specific date. There is no timeline for the State House of Assembly to return. You now need to deal with their benevolence, appeal to their benevolence, and say, okay, my colleagues at the state level, please, let's have your returns by end of May.
And you know, Mr. Jide, if you look at the recurring nature of some of the bills being proposed in our National Assembly, I mean, in our constitutional amendment process, it gives it a feeling of, you know, something that looks like the end has been known almost from the beginning of the matter.
Exactly.
You know, some of the bills, they keep reoccurring, but it's like, oh, we already know it's not going to fly, but just have it.
Just have it.
We have,
like the issue of independent candidacy, the president will not sign.
Exactly. So the whole amendment process looks like a ritual.
It's a hollow ritual. That's what I'm saying. It's a hollow ritual that is kept reoccurring because of pecuniary interest, you know, of the members of the National Assembly. That's one. Two, because we have failed to lay this ghost to rest. If we have a newly written constitution and a new I will expect a new president by 2024. We can have a brand new constitution that will be pro-people.
Well, we'll talk about...
You can have 2 years ahead of election of implementation.
Okay.
But when you are look at the issue of independent candidacy, issue of there's 1 or 2 other that borders on our elections. Do you think that will meet 2023 elections? It cannot, because already INEC has released timeline and schedule of activities. INEC has by that saying that primaries will hold from April to June. Yeah. So even if a constitutional amendment is effected today and the president signs into law before the end of the year, it can only become operational as regards elections until after the election. All right,
well, we'll revisit that when we come back. We'll take a short break now, and then when we come back, we'll talk some more on the constitutional amendments, specifically the politics and also the obligations of lawmakers at the subnational level. Please stay with us.
The idea was to give the interim government confidence that there is somebody, a military man, who is well known, who can be accepted.
You alluded to the case of your son, Umar Farouk. Are you in touch with him?
Yes, he phones us 2 times, sometimes 3 times in a month.
As always, when I'm talking about late Abiola, I still thank my God for directing me on things to do when he gave me that leadership of this country.
Many of you honest Fulanis, you allow this man to cast aspersion on you. You know, Zamfara is the mother of all bandits.
The biggest problem, if you permit me, is the fact that we have not been able to get the totality of our citizenry.
It's very, very difficult to have a fixed mind like that this one you will hand over to this person because you think you will do better.
I don't see myself under no circumstance ever leaving APC for another political party.
Here on the Mambila Plateau. And this is where the hydroelectric power dam is supposed to be constructed.
Most people in Nigeria are ignorant of the fact that employing a child as a maid is in fact against the law.
Access to the textile mill has been very difficult.
I believe, or I think that if you want to make money, it should be in a place where there are not plenty of people that can do what you do.
From the way things are happening now, I don't think the two parties will make any impact.
I've been talking about the updates concerning the campaign of Nigerian Super Eagles in Abuja.
Bola Tinubu has informed President Muhammadu Buhari of his ambition to contest for the position of president.
To be self-reliant, a blind man defies all odds to become a carpenter in Gombe State.
The country is now experiencing a fourth wave of the COVID-19 pandemic with the emergence of the Omicron variant.
Talks are ongoing between NRC management and the union.
All right, thank you for staying with us. If you're just joining, you're watching Issues on Trust Television. I have in the studio Jide Ojo, and we are talking about the constitutional amendment and the matters arising from that, the politics and also the role of lawmakers at the subnational level. Well, I mean, quite a number of issues that we have seen in these constitutional amendments. Now, there are some very critical ones that affect, the current realities that we're dealing with. For instance, the issue of insecurity. There's this proposal to set up, state security councils at the subnational level. So I'm just thinking, to what extent would this help, in curbing the issues of insecurity, especially in the northern parts of the country?
I really don't know to what extent that will work, given the fact that the state has been having Security Council meeting anyway. So whether there is a constitutional amendment or not, each time it was from many of the state Security Council meetings that they resolved to ban motorbikes, commercial cycling, in some states that have banned commercial cycling. It is after the State Security Council meeting, maybe the Commissioner of Police in the state will say, on the advice of the Security Council, they now have banned, or commercial cyclists or commercial cycling on some routes, as the case in Lagos, or even in Abuja here, where they have banned the use of commercial motorcycling on major roads in the heart of town. So I really don't know for what benefit this having a constitutional amendment to give legal backing to states having security council. I don't know what added value that will bring, because whether we like it or not, security is everybody's business. It may well be that they just wanted to have a legal backing to what they are already dealing with administratively. Because it was the Security Council of States that recommended, for instance, that Southwest should have a joint security network called Amotekun. It was the security meeting of each of the states that eventually agreed to sponsor the bill that would give legal backing to Amotekun in the 6 Southwest states. And they all did. So it's already operational. Why they want to do this, maybe when we see the nitty-gritty of the law, because these are just more like headlines. These are just more like the topic of those bills. We need to know what the content of the bills are. But on the surface, if it will add to helping in solving our security challenge, it's a welcome development.
All right. Now, the constitutional amendment seeks to empower the state assemblies some more and the National Assembly. For instance, if you look at the bills proposing for the summoning of the president or the governors to appear before lawmakers to answer questions as regards, issues, within their states or, within the country, issues of giving timelines for appropriations to be submitted to the National Assembly, issues of, also giving timelines for the setting up of cabinet members or, state executives, and the likes, issues that has to do with, State of the Nation address, making it compulsory, by lawmaking and all that. When you look at some of these provisions, are there likely, hood of them being, passed at the state levels?
Yes, there are likelihood of some of them, but I doubt if the president will append his signature to some of them. Like the issue of summoning the president and the governors, it won't fly. It won't even make the cut, because they want to retain that prestige of being, because that will subjugate the governor and the president to the whims and caprices of the president.
Isn't it the whole idea?
Assembly.
Isn't it the whole idea? The National Assembly, the lawmakers, they are representing the people, isn't it?
Yeah.
Both at the national and state levels. So you could say these are the people I work for. It's supposedly the arm of government that has that. Power,
I understand, but I do understand your perspective, Ayuba. But I am saying that the Nigerian leaders of today will not want to be summoned. Recall the last exercise that happened between the President Buhari and the House of Reps over an issue of insecurity, when the House of Reps summoned the President to come and address them on the worsening insecurity. And initially, they went and had the meeting with the president. The president gave his word that he was going to appear, only for the governors. In that regard, the governors were the ones that even went to appeal to the president, not to honor that. That will make them to be dragged around by the assembly. So on the advice of the Attorney General, Minister of Justice, and as well as the Nigeria Governors Forum, the president refused to honor that invite to come and address the House of Reps, which he had already consented to. Because I recall that Right Honorable Femi Gbajabiamila, House of Reps Speaker, met with the president, and in fact, he granted the press interview and said they were not summoning the president, They were inviting the president, and he tutored us on the difference between summon and invitation. That in summon, you do not have choice. That if they say appear at the Senate building, room 001, by 10 a.m., you have to. But when you invite, you can say, okay, Tuesday is not convenient for me. I would rather come on Thursday. Instead of 10 o'clock, I would want to come around 2 because I have further engagement. In which case, you have your discretion and you can negotiate. But be that as it may, whether it was someone, whether it was invite, the president failed to honor that.
And so it is for some appointees as well, not just the
exactly.
president.
So if you now make that constitutional matter, they will not feel okay with it because there are...
But isn't that supposed to strengthen the issues of transparency and accountability, to the people?
It may seem so, but I also would not agree. The point is this, there are too many committees in the National Assembly. Too many committees, like House of Reps has over 80 committees. The Senate has over 40 committees. If each of the committees have the power to summon the president, even over issues that a minister or head of an agency would do to come and explain, like now you summon...
Yeah, but we are talking the president coming to address in a joint session of the National Assembly,
no,
not committees.
That's not the way it's put in this amendment. The power to summon the president. If you approve that, different committees will be scheduling summon for the president on the same day. So when will he have time to govern? I do not believe. I think this can be worked out.
How about if we make it such that the president only appears before a joint session?
State of the Union address.
Something like that.
I agree to State of the Union. So once every year, he goes to give State of the Union.
Or maybe address. Twice every year.
You can make it twice a year. Go and address it. But for you to summon the president, when you have so many committees, and you are not, unless they qualify to say, to address a joint committee of the National Assembly, in which case you have no committee will have the power to summon the governor or the president. That would make sense, because I know politicians, they like to grandstand. You just see it on network news. The Committee on Aviation has given 48 hours to President Muhammadu Buhari to appear before it on Thursday, unfailingly, that kind of thing. That will cede a lot of power to the Assembly. So I reason that one will not fly. In fact, the governors will not allow it to pass. But the other ones, the issue of submitting appropriation bill 3 months to the end of the year, that one is already in Fiscal Responsibility Act 2007. It's just that it has been observed in breach. Because the Fiscal Responsibility Act has said the president and the governor should submit the appropriation bill 3 months to the end of the year. But not so deaf as those who will not hear. Again, this made the court in the last exercise, in the last constitutional alteration that was carried out in 2018. But the president did not sign. The president, it was one of those 12 bills that the president did not sign. So then there is also this other one you mentioned, yes, State of the Union address.
The cabinet members.
The cabinet, okay. A timeline for appointing cabinet. I'm fully in support of that. We do not want a scenario where we'll be taken back to this 2015 experience with President Buhari, that in 5 months he couldn't get the people that you work with him. And Constitution in Section 147 is very clear that you have to appoint your cabinet, but there is no timeline. And we have found, since in the situation in my neck of wood in Osun State, where the governor, Aregbesola, governed for a whole year without a cabinet, without commissioner.
And budgetary allocations are made to all of those departments.
The same thing happened in Edo State, where the cabinet, 10 State House of Assembly members, don't let me conflict you. In Edo State, Obaseki, after winning his re-election, did not form his cabinet until over a year, because they could not agree on harmonization of the list. You know, he defected from APC to PDP. And for those who defected within, he felt he needs to compensate them. The PDP people said, no, you cannot go and be giving our slot to APC. So that they could not find a mid ground for over 1 year. It was only recently that he formed his cabinet. But assuming that we have a law like this, that already said within 3 months, 90 days of your being inaugurated, you have to form your cabinet. That helps. Look, Biden, I recall that Biden was elected in November of 2020. By January 2021, when he was inaugurated, he already has his cabinet.
Now, how important is this, to the economy, to the running of the governance of the country? To what extent does it affect, the smooth running of governance?
It does, a lot. There are certain policy decisions you cannot take, or some, what's it called? Convention, treaties, and other obligations, even when you want to borrow money. The DG budget cannot go and sign on behalf of Nigeria. Do you get it? It has to be a substantive minister.
All right, let me get
the same thing with Attorney General. There are certain national treaties or conventions that has to be the ministers expressly mentioned. Right. So when you don't form your cabinet early enough, it impacts governance because it will only be acting. Permanent secretary have their own schedule. They cannot act for a minister. Otherwise, he can review whatever is done before his inauguration.
Okay, quickly, let's talk about, let me get your own thoughts about immunity for presiding officers of the National Assembly. I mean,
thankfully, it didn't fly. Thankfully, it was one of those bills that were rejected. I feel that was self-serving. It was self-serving because why should you be giving yourself immunity? For what reasons now?
Same reasons as the executive.
No. You should not be in competition with the executive. If you want to be a governor, resign your membership of Senate or House of Reps and go and contest to be governor. You cannot be dragging immunity. I'm happy that the National Assembly developed muscle and rejected that immunity clause for their principal officer. The same way they rejected life pension for their principal officer. It was also one of those bills that were rejected. They want life pension for being president of the Senate. They want immunity for being president.
Do you think that this is the work of the governors, at the back end as well?
I don't think so. Because the governors were not in a position to dictate to the Joint Committee of the National Assembly. They
have representatives and senators from their states.
Yes, but even for issues like state police, it didn't make the court. They didn't even table issue of state police for voting. It was not one of the issues that were tabled for voting. So my gut feeling is that they just wanted to make the number. And maybe people lobbied and said, just let it be. If it's rejected, at least people will know that we try to do something along that.
All right. Now, finally, before we go, we must talk about the gender bills. They didn't pull through at all. And
very unfortunate.
The women are not happy about this. In
I'm
fact,
not happy about
we saw
it.
the First Lady herself, in the chambers to push for this. But at the end of the day, it didn't even pull through.
Because the
affirmative action wasn't there. The issues of, more seats for women in the National Assembly and also
even citizenship and indigeneity bill, 5 of it. Ayuba is very unfortunate. And I think Nigeria is shooting itself in the foot. We have not come to understand the role of women in our national life. Women, there is no governance I've seen that can succeed without women. It's the same analogy I draw. God that created bird, or bird, as it's called in local parlance, that it flies with both wings. Have you ever seen a bird with one wing? Have you ever seen an aeroplane that flies with one wing? Have you ever seen anybody that claps with one hand? The female folks, women, makes up 49% of the population, at least by the 2006 estimate. That is like half of your population. If you now sideline half of your population, on what basis?
Well, if you look at some of the arguments that have been made, on this, about 111 seats. We are already complaining about cost of running the National Assembly. Now, if you add this number, you have more than 500, seats for lawmakers, alone. So looking at the budgetary allocation that will have to go into servicing all of that, are you not concerned about that?
No, not that I had expected all the 5 gender bills to pass, but at least 2 or 3 could have passed. The issue of indigeneity, that if you are married to a man for 5 years and is a foreigner, he should be able to acquire the nationality of Nigeria, which is what works for a woman. If you are married to an American for 5 years, you automatically get the nationality of US, and that should have been that I think would not have harmed us. Unfortunately, that was rejected. The issue of even this other one, I took exception to issue of creating additional seats. What I'd expected to be proposed is that from the existing 360 seats in House of Reps and 109 seats, that 1/3 of it should be reserved for women. And then you can decide on modality for starting. So there are A to Z states, Abia to Zamfara. Then you can say for this first round of first time from 2023 to 2027, the following states, one maybe Abia North or one of the 3 senatorial seats, out of 3 will go to a woman. So it will not be rotated.
But some civil society organization persons feel that it's not going to work if you say that should happen. Who is going to sacrifice his or her seats?
It can work. And mark you, even if, for instance, you didn't approve that for the parliamentary position, what about appointive? Why can't we make... See, we have gender policy that talks about 35% affirmative action. But it has been observed in breach. President Buhari at National Women's Center made a promise that when he wins, and if he wins the 2019 election, 35% of his cabinet are going to be made of women. Now, 6 out of 43, does that amount to 35%?
Okay, all right. Now, 2023. Is there a likely chance of this having an implication on the votes for women in 2023 and how women are going to be participating in that election?
I'm a he for she, and I have advised that look, women should put their money where their mouth is. They have the numerical strength. Men may even be more on the register of voters, but women are more committed to come out and vote, and that they should vote for one of their own. If there's a woman who has won the nomination of her party, they should not say if it's either APC or PDP. Even if the person is ADC or in ABGA, they should vote because it's a game of number. You don't expect 6 senators in the National Assembly out of 109 to make any difference in terms of voting strength. Because even if the 6 were able to vote for gender bills, what about the preponderance of men that are not convinced that they... And the unfortunate thing about these gender bills is that the president is not even an he for she person. You had the statement he made about castigating as well, that the role of women is in the other room and all of that. And that if the president has put his weight behind these gender bills and said, add meetings with women groups and say, look, I can't promise you 5, but 2, this and this. I tell you, the National Assembly will have voted in support. And then it lobbies the Governors Forum. Because, look, the Governors Forum, APC alone has 22 states. If the president is involved in these gender bills, and we have 22 APC votes in the State House of Assembly, all you just need is to convince 2 other states to join the 22, and you have the court. And the president will be there to sign. But the moment the president himself is not convinced about the role of women in governance, that's why you saw
quickly,
what happened.
in 1 minute, because of time, we'll have to round up. But in 1 minute, what would you say to those who say, well, why don't the women just come out and compete just like anyone else? Why do we need to be given some kind of special treatment or special arrangement?
You need to do that because of long years of discrimination and marginalization of women. the stories are out there. It's very shocking. I've been involved in research on gender issues for over 10 years now. And I do know it's not a joke. In elections, women will win primaries and they will give the ticket to a man because they feel that a woman is not electable. Whereas women are electable. So the bottom line is that it's about attitude. It's not even about law alone. Even with the gender-based passing, if the attitude, our attitude to our women folks do not change, nothing much will be achieved. Let me quickly cite this example. A woman lost her husband. The husband died. And in Igbo land, a woman cannot inherit the property of her husband. Only the children can. So this lady went to the court and fought her way from Federal High Court to Supreme Court. And Supreme Court said, you know, women in Igbo land are supposed to be to inherit their estate of their husband. But did you know in many communities, despite that Supreme Court judgment, many communities in Igbo land discussed it and said that is the court. For us here, tradition, customs hold. So
it goes beyond the law.
It goes beyond the law. It's about attitude, it's about customs, it's about patriarchy, it's about this myopic thought about governance. In the Scandinavian countries where they have more women in parliament, you could see their gross domestic product, their national income, they have better standard of living than even Americans.
All right, well, thank you so much. Unfortunately, we have to end the discussion. Thank you for coming on the program and sharing your thoughts with us.
Always a pleasure.
Jido Ojo, political analyst and also public affairs analyst, is the one who has been giving us his perspectives on some of the issues coming out from the constitutional amendment. With that, we've come to the end of the program for today. Connect with us via our social media platforms and also subscribe to our YouTube channel to watch us live. I am Ayuba Elia. Thank you so much for watching. Join us again next time.